Welcome to our Thursday Deep Dive webinar. I'm Yomika Bennett, Executive Director of the New York Charter Schools Association. Before we dive into our discussion today, I wanted to make New York City Charter Schools aware that the State Education Department announced that one-time bullet aid for New York City Charter Schools serving students in the 2019-2020 school year will be released by the Division of the Budget. SED will make payments to charter schools through through their grants system. No application is needed, and payments should be processed shortly, so look for that. Okay, we're here today to talk about Education Law 2D. Education Law 2D refers to Section 2D of the overall education law in New York State, which addresses unauthorized release of personally identifiable information. If you're interested in seeing the full text of the law, we're going to drop a link into the chat. While the law went into effect in 2014, additional provisions were added that will take effect October 1st. They were intended to take effect earlier this year, but got delayed due to COVID considerations. These additional provisions require, among other things, that districts, including charter schools, identify a data protection officer, publish a parent's Bill of Rights for data and privacy, and include that Bill of Rights in every third-party contract with an organization that might receive students' personally identifiable information. Understandably, this has raised a lot of questions for charter schools, and we wanted to take the opportunity to review the new provisions and field questions in advance of the October 1st effective date. This is why we're thrilled to be joined today by Kirsten Barclay of Bond, Shennick & King. Kirsten's practice includes representing charter school clients across New York State in all areas of school law. Prior to joining Bond, she served as in-house counsel to a large city school district. Kirsten has helped charter schools with school improvement and innovation, designing effective operating systems, and with implementing laws, policies, and practices in ways that support improved student achievement. Kirsten, welcome. I'll turn it over to you for your presentation, and then we'll take questions using the Q&A.
Thanks, Yomika. I'm just going to share my screen. So thanks everyone for joining this afternoon. As Yomika said, my name is Kirsten Barclay, and I am Senior Counsel at Bond, Shennick & King, and have the privilege of working with the folks at New York Charter Schools Association and Northeast Charter Schools Network. So very happy to be invited to join you today. As all lawyers do, I have to give you a couple of disclaimers. The first is that this is happy to share as much information as possible about 2D, but it does not constitute legal advice. The second is that I want to make sure you know this is intended to be an overview, and so there are details missing, and would encourage you to work with your counsel and get to know the regulations. If you are on this call because you are responsible for 2D in your school, it's worth the time to dig into the actual regulations. And then the third is I am working remotely, and so I'm going to apologize in advance if I am interrupted by any children. So hopefully I will not be. So as Yomika said, Education Law 2D imposes obligations on charters really to take action to strengthen data privacy and security. You want to be doing this both internally within your school and also with respect to your agreements with third-party contractors. 2D applies to data, to two types of data. The first is student data, and the second is teacher and principal data related to APPR. Today, I'm going to focus exclusively on student data. Lastly, as Yomika mentioned, originally these regulations were set to go into effect on July 1st, but got extended by the regents until October 1st. And so at the time that felt like a really long time away, and suddenly here we are, and it is October 1st. And so it is time to hit the ground running with 2D implementation. If you're not familiar with kind of how this all came about, I'll just give you a quick background. Back in 2013, there was kind of a national conversation going on as school districts and charter schools and state education departments started kind of being overwhelmed with the amount of student data that they needed to store and manage, and started thinking about outsourcing it. And so 2D is really designed to be sure that when it's outsourced, that it is also protected. So in 2016, the State Ed Department appointed a Chief Privacy Officer who is responsible for overseeing 2D implementation. And that person created an advisory council to help draft the regulations, as well as the Parents' Bill of Rights, which is a really big part of what 2D seeks to accomplish. And the last thing that I think is just really interesting, especially if you have a kid interested in science in your school who wants to do a history research project, the National Institute for Standards and Technology is now part of the US Department of Commerce, but it came into effect in 1901 in the United States and does a lot of really interesting things, one of which is creating this framework for cybersecurity protection. And 2D adopts NIST's framework and requires schools to also adopt the framework. So I'm sure that most of you are familiar with FERPA. 2D borrows a lot of the definitions from FERPA. So as you think about the definitions that we're going to be talking about, you should recognize these as kind of standard definitions that you see. Specifically, the thing to know is that student personally identifiable information from the student's record is what is covered by both FERPA and 2D. And the information that we're used to talking about, like student's name, address, social security number, and student number, that's pretty routine, and we remember all the time that that is protected information. Just something to keep in mind, though, is that indirect identifiers are also protected under 2D. And so if you have characteristics of a child, for example, that could allow for their identification, then you want to recognize those things as PII that is protected. Again, borrowing from FERPA, disclosure can be intended or unintended, and you want to, and it can be done by any means. So it could be you having a conversation with a third party about a specific child. It can be the sending of the actual paper file that you keep in the main office, or it can be the electronic transfer of the records. And specifically, I think 2D is interested in the transfer of those records to the third-party contractors that we all work with. In order to disclose information out of student records, FERPA requires a signed and dated written consent form, same obligations in 2D. And schools are required to maintain and keep records of both requests for disclosures and also disclosures that happen. And parents have a right to inspect those disclosure records along with their students' education record. So I mentioned records, and it can be the paper file in the office, it can be emails, it can also be videos of a child. And a good example is, if you have a security camera and it captures a student doing something they're not allowed to do, and you use that video as a basis for disciplining the student, then that video is considered an education record. So there are three main federal laws that are linked to 2D to keep in mind. FERPA we've talked about. The other one is the IDEA, and I mentioned indirect identifiers. The IDEA explicitly protects special education students' PII, and they define it as personal characteristics or other information that would make it possible to identify the child with reasonable certainty. I think this is important for charter schools to keep in mind because many charter schools have a relatively low incidence of students with disabilities or students, English language learners in their schools. And so if you're going to showcase, for example, a specific student and you don't have that many students with those characteristics, you want to be careful that you are not inadvertently allowing them to be identified without consent. And then the last law that is directly linked is the Child Online Privacy Protection, which really applies to online service providers that direct their services to children under 13 years old. So this is like online gaming systems or like the little kid reading programs. There are requirements in there that require parental consent, and schools act in the position of a parent when they agree to the privacy and terms and conditions of those programs. So I think about Ed Law 2D as applying to three kind of entities. The first is state ed. The second are you all and other educational agencies like BOCES, school districts, 853 schools, and then independently of kind of the public actors, also apply to third-party contractors that receive PII. And that is kind of under the theory of like, if you're going to do business in New York State, then you are going to follow, you know, our rules around protecting children. I've listed some examples there of the types of vendors that I expect most of you work with on some level. And so if you're working with these kinds of organizations or individuals for things that include transferring or them receiving PII, then those folks are also bound by 2D. So quickly, just talk about the state ed department's obligations under 2D. 2D limited the type of data that state ed is allowed to collect. And so they are only allowed to collect information that is related to an education purpose and where it's required or allowed by law. And importantly, I think it prohibits state ed from collecting information related to juvenile delinquency and criminal records, medical records, and biometric information. The other thing 2D does is requires the appointment at the state ed department of a chief privacy officer. And that person has some powers specifically around access, looking at the records that are maintained by the school and requiring you to conduct a security risk assessment to make sure that your practices align with NIST. They also are charged with investigating reports of breaches and unauthorized disclosures of PII, and they have the ability to impose civil penalties and actually refer cases to law enforcement where they believe there is a criminal act. So the charter school obligations, which I think are most important for the folks on this call today, can be thought of in 7 kind of buckets. And we'll walk through each of those. So the first obligation is that you need a board policy for data privacy and security. And there are mandated components of the privacy that you can find directly in the regulations. They generally include a requirement that your school is going to align their technology practices and safeguards with that NIST framework. That any use and disclosure will be for the benefit of students or school operations and not for marketing or commercial use. That PII will not be disclosed in public reports, and the policy must incorporate all of the FERPA and IDEA protections. The next bucket is kind of just the in-school practices for privacy and security. Again, your IT department or your data privacy officer is going to want to ensure that all of your practices align with the NIST framework. Again, you cannot use it for marketing purposes. And also I would suggest that you take a look at how much data you're collecting and processing and transmitting on student PII, and make sure that it's kept at a minimum. I know that we're very data rich now, and we use data to make a lot of decisions. Just be sure that those are all necessary collections and uses and transmissions. A big one for charters is that they have to ensure that all of their contracts with third-party vendors are 2D compliant, and we'll talk about that in a minute. And then, of course, you don't want to report data to state ed that is outside of those limitations that state ed is allowed to collect. 2D requires every school to appoint, every charter school or LEA to appoint a data protection officer. This has got to be a person with appropriate knowledge, experience, and training to administer the requirements of 2D. So there are, I've listed some of what those requirements are so that you can think about like who the person would be. The person has to serve as the school's point of contact for all data issues. They should register with the state ed department on the website so that they are recognized as the data protection officer for the school. They are charged with implementing the board policy and the school's practices, including complaint procedures that are brought maybe by parents or faculty. And then very importantly, the data privacy officer, protection officer is required to report breaches or unauthorized disclosures of data to the chief privacy officer at State Ed. These would be breaches that the school becomes aware of from a third-party contractor. And it's not optional whether you report those breaches, even if your vendor tells you that it was breached, but it's been resolved and it's all taken care of. You still have an obligation to report. And then there is an annual awareness training requirement for all employees with access to PII, and an annual notice requirement of the policy that it has to be made to officers and employees. And then finally, an annual reporting requirement to the board that includes a summary of any complaints that you've received. So the next bucket of obligations are the charter's obligations to protect or share parents' rights. And there are three kind of sets of rights that parents have. The first is found in a required Parents' Bill of Rights for data privacy and security. And this really is is part of the policy, and it gets posted on the website, and it says many of the things that we've already talked about, that the school can't sell or release the PII for marketing, that parents have a right to make complaints about breaches, and how they can do that, and that they have a right to be notified if there's a breach, and also that the employees of the school are going to be receiving annual training on how they should be safeguarding PII. In addition to that Bill of Rights, for every single vendor contract that invokes PII, you have to generate a supplemental information. And that is very specific to each of your contractors, and it includes a summary of the exclusive purposes for which that contractor will be using PII, how they're going to ensure that they protect it and that their subcontractors protect it, how long the contract lasts, so when the data begins, the date it expires, and then a description of what's going to happen when the contract expires, and how the parent can challenge the accuracy of the data that's being collected. And again, those supplements must be posted on your school's website. Another parent right is that you establish and communicate procedures for filing complaints about breaches and unauthorized releases. This would also apply to staff who would want to file a complaint, but is included primarily, for parent purposes here. You can require that the complaints be submitted in writing, and if you're going to do that, we suggest you put a form for the complaints on your school's website. And then there are very strict regulatory timelines, but for acknowledging the receipt of the complaint, investigating the complaint, and then taking any precautions. So from the date you get the complaint, you have 60 calendar days to notify the staff and parents of the outcome of the complaint. So you'll recall that I mentioned that third-party contractors have independent responsibilities, and we are going to get to those, but I wanted to take a minute and talk about two primary obligations that the charter schools have with respect to their third-party contractors. So the first of those buckets are ensuring that you have 2D compliant contracts with your third-party vendors. The first thing we recommend is that you sit down and make a list of all of the vendors that you work with, including, as I mentioned, those software licensing agreements that are non-negotiable, pop up online, and you click to agree to them. Examples of these are Zoom, Google Meets, and so really need to just make sure that you step back and make sure that you get agreements in place, and we can talk maybe in the Q&A about how you can do that. If you work with an education service provider or a charter management organization, you'll need to amend your contracts to incorporate the 2D requirements. And then also any data management contracts or program evaluations or audits where PII is implicated need to include or be amended to reflect 2D. So what are those amendments to the contracts? They're generally that the vendor agrees to comply with 2D and your policy, that they agree to hold their subcontractors responsible for compliance with those things. The vendor has to sign the Parents' Bill of Rights, which gets incorporated into the contract itself. And then the vendor has to put forward a data security and privacy plan that is accepted by the school. And in you signing the contract, that signals your acceptance of that plan. The second obligation that you have with respect to the third-party contractors is breaches and unauthorized disclosures. So the simplest way to think about this is that the data storage company, gets hacked and the kid, 100 of your students' files get stolen. If your vendor calls you and says this just happened, there are regulatory timelines within which you have to report that breach to state ed. You have to report it to your school community, and the notice that you give in that report is very specific and in terms of what it needs to include. Finally, I'll say that the regulations say that you can mail, email, or provide or make telephone calls to provide notice, and we of course would suggest that you do it in writing. So in the beginning I mentioned FERPA record keeping. You are required to maintain records of all complaints of breaches or unauthorized releases and the disposition of those complaints in accordance with data retention policies. Right now, State Ed has not updated its retention schedule to include 2D, and so for now we're recommending that you follow the 6-year rule, which is in place in New York State for just general complaints. And the last in the bucket of charter obligations are the things that need to be posted on your website. So you'll want to get the board policy on the website, the Parents' Bill of Rights, that supplemental information for each of those third-party contractors, and the complaint procedures, and then the contact information for the data privacy officer. I'll take a couple minutes and talk through just what the third-party contractors' independent obligations are, because I think it helps you get a sense of how much of the same things they're responsible for. So they should be doing these things at the same time you're doing these things. I think we've talked quite a bit about this already, but in terms of who is a covered third-party contractor, these are individuals or entities that receive student data pursuant to a management or pursuant to some type of written contract. The only kind of exception that I think is worth noting is if you partner with another, like say charter school, for example, to provide you support with teacher coaching, those other charter schools are not bound by 2D for purposes of that contract. So there's a laundry list of independent responsibilities under 2D for third-party contractors. Most of these will sound very familiar to you because we've already talked about them and you have a lot of the same obligations. I want to just take a minute and talk about the data privacy and security plan that the vendor puts together that goes with your contract, because I've gotten a lot of questions about this from clients. What does it mean to accept this plan? The regulations delineate exactly what has to be required in the plan. And so you can take a look at those, but really what you want to know is the hows of how your contractor is going to accomplish the intentions and the requirements in 2D. So How will they demonstrate compliance with your board policy and the Parents' Bill of Rights? How are they going to provide training to their staff and making sure their subcontractors get that required training? And then how are they going to manage incidences of breaches and commit to notifying the school? And then finally, those plans should describe what will happen to the data at the end of the contract. Will it be returned to the school? Will it be destroyed? And if so, how will that happen? So again, the regulations impose independent obligations on the part of the third-party contractor. If they discover a breach, they have 7 days to notify the school of the breach, and you would in turn report that to the chief privacy officer, and the contractors also have to agree to cooperate with the privacy officer and law enforcement. I mean, the regulations require that they cooperate. And then just to give you a sense of what this can mean for vendors, they can be precluded for access to being a bidder in New York State and access to PII, even if it's a no bid contract, for up to 5 years. They can be fined up to $10,000, and they can be obviously reported to law enforcement if the chief privacy officer thinks that there's criminal activity. So I would encourage you to take a look at a couple of resources on State Ed's website as you're developing these things. They have a template for the Parents' Bill of Rights, and they also have a data incident report form for your data protection officer to use to report any breaches or unauthorized disclosures. I tried to put back on my charter operations hat and think of like, all right, what do I need to do right now? So here was my list of things that I needed to do right now. First of all, I need to assign a data protection officer. I need a board policy in place. I need to get that list together of all of the vendors that receive PII. I need to check with my tech people and make sure that we are actually complying with the NIST framework and that we have best practices like encryption and firewalls in place. And then finally, I would want to take a look at what's on my website and make sure by October 1st that all of my required website information is up and running. So with that, I will stop sharing my screen and hand it back to Yomika.
All right, Kirsten, thank you very much for that. We already have a number of questions in the chat. I think I will take the opportunity to answer one question that came up, and that's about the presentation, and just confirm that we will post the presentation on our website with our webinar later today. And with that, I will turn it over to you, Anna and Kirsten, for the Q&A.
Thanks for that, Yomika, because that was also going to be my first headline. And I will thank you, Kirsten, again, and we will probably drop her email in the chat because she is a great resource to charter schools on many things, including this. And I'll just say before we dive into questions, Kirsten and I were talking in advance of the presentation and sort of generally saying like, this just feels like not the world's most exciting piece of compliance, but I would underscore the urgency that some people feel about PII, in particular children's PII, and that SED feels very urgent about this. And so if I were to look at Kirsten's great practical consideration slide, I would think about what are the things on here that are going to be the most evident, the most quickly to SED, because I do think that they are going to be spending time through the fall following up with schools who have not visibly complied with these requirements. So with that, I'm going to dive into some Q&A. So yeah, someone also asked, we will post both the recording and the deck. So you do not have to worry about having taken furious notes, and we should have said that at the outset, our apologies. So Kirsten, a couple of sort of related questions. So one, what's a good way to get sample language for the board resolution or a 2D policy? And then similarly, are you aware or do you and BSK offer consulting on things like 2D compliance?
Yeah, I have several of my clients I have already been working with to make sure that they have a 2D policy for their board. And then I think importantly, this is one of those compliance things that's like, if you dig into it and focus on getting it right out of the box, it's gonna go well. It's not gonna feel like this overwhelming ongoing thing that you have to deal with. But I do think there's a lot of pitfalls along the way if you don't kind of sit down, focus, and try to like internalize what this has to look like in practice. You may find yourself pretty quickly out of compliance, particularly if you, like my biggest kind of fear is that example that I gave, that you get a report of a breach that's been resolved from one of your vendors and you're like, oh, well, it's been resolved, so it's fine. You know, knowing in your head, like, it's not fine, I still have an obligation to report it. I think in the long run, getting this right up front is going to save everyone a lot of time. And so, you know, we are working with clients on everything from just the policy for people that have IT departments and feel like they've got it covered to going in and doing the training for both the data protection officer, who is then kind of going to turnkey training to like their whole staff, and then also, you know, providing training to the staff. And then the biggest time kind of commitment has been around these contracts with third-party vendors and doing riders to these contracts and making sure that everyone understands what's required of them.
And so to follow on to that, Lauren asked in the Q&A, so what has to happen by October 1st? Can I essentially say everything? The training, the board resolution, the data privacy officer, this law is live on October 1st. And so all of those things that you listed in your practical considerations by October 1st?
Yeah, I think well, I agree with you, except with maybe the exception of the training, because that's an annual requirement and the notice is an annual requirement. So I don't think that, I didn't see a requirement that has to be done before the law goes into effect. I think for me, it's those contracts and that website stuff in the board policy. And then just having, you know, if you're a school leader on here right now, like figuring out who your person is that you can trust with this. And I would discourage school leaders who are instructional leaders, you know, trying to manage all of the remote instruction from taking this on if it's at all possible that they avoid it. It's just, again, it's that upfront kind of sit down, figure it out, implement it, and get it up and running time that probably most people don't have right now.
I think that's, well, as a former, and I won't even say recovering because I'm team ops, I will totally echo that. And I do think that there is an important first task when you say make the list, and that is potentially a joint task between instructional and operational folks. Just sit down and make a list of sort of all your platforms, right? All the things. And the problem, I mean, or the additional challenge in this moment is that list is probably twice as long as it was in February. So what are all the platforms that teachers and students are interacting with? And where is it possible that student data is being entered? And can I just clarify for my own understanding, because even thinking about my own kids who go to a charter school who are doing remote learning right now, if they got a login information in order to participate in remote learning, that means that somewhere their name and age and grade level, that is PII, correct? So if you are using any sort of a platform that students have to log into in the context of remote learning, you would need an agreement with that platform around PII. Am I getting that correct?
Yeah, I think that's the safest way to do it. The only way that would not be the case is if there were like de-identifiers, you know, that the information was going into that platform, completely random identifiers for kids, and nobody could, even in a year from now, looking at the kids' performance and looking at, you know, what
the books you read on Epic, the math you did on Dreambox. I don't know if I'm,
those are all. Those are all all of those companies are collecting information related to kids, and eventually they get, it's like TikTok, right? Like I told Anna earlier, you know, I'm pretty sure TikTok knows exactly who my teenagers are at this point and where they live and like what they spend their days doing, because Not because they entered information necessarily, but because over time, there's been so much information about them collected that somebody could piece it together at this point.
So I want to circle back to something that you just mentioned that Vicky asked a question about in terms of this annual awareness training. Because it is annual, your interpretation is that that doesn't have to be by October 1st, because if October 1st is sort of day one, you theoretically have 365 days after October 1st in order to conduct that training. Is that accurate?
Yeah, I mean, legally, I think that's accurate. I would not ever suggest that's a best practice to wait till next summer to do training, because you're going to end up with compliance problems if your teachers don't know what they don't know, right? So if I don't know that I can no longer use some software thing that I think is great for entering my grades or, you know, keeping my lesson plans, then you're going to end up pretty quickly violating 2D.
Yeah, and I would just also add that I find 2D to be a really interesting intersection with a training that when I was still in a school leadership position, we developed a training around for staff to remember that they are public employees. And that means that if you produce a document and it is saved in any way, and that email counts, if you are using a company cell phone or something like that, and you are discussing a student, that you have created an enduring record. And I think that that is potentially even more important to know and recognize and train your staff on now than it was back in February. Because in February, you can be in the staff room and blow off a little steam about a certain student. In September, if you're doing that over email and God forbid anything ever becomes an issue, those are achievable records that can become part of a lawsuit or things like that. And so just this idea that if student information is precious, and it's precious at the level of your interaction with these platforms, but it's also precious at the level of interaction among adults. And if you're writing it down, especially in a digital format, it will live forever, for better or for worse. So Miriam asked a question, going back to Kirsten, your great guidance and my team ops salute. Who would you recommend as a data privacy officer?
Every charter school is so totally different in terms of their leadership structure. So it's very hard to name a title of a person who I would say you should focus on. I think it should be a person who really understands how IT works, who understands what cybersecurity means, somebody with authority to speak on behalf of the principal if there's a report made to SED. Want to make sure that person can invite SED in to investigate files, can partner with SED to come up perhaps with an improvement plan or a corrective action plan around data security. So, and if you have an IT director, that's probably a good place to think about. If you have a director of operations, that's probably another good place to think about. But I think, Anna, one of the things you said is like the partnership with the instructional team in getting the universe of what you're looking at put together in the beginning is also really important. So it could be that you have an assistant principal who's just good at this stuff, who can lead the deep dive into it and then your team comes up with a plan about what it should look like.
I think that makes a lot of sense. And I will say, we at the association, team ops, we're happy to be helpful. And I know Kirsten and her team are as well. So I'm actually going to mix it up a little bit for those of you who have joined us on previous Thursdays and bring Becky into this conversation because there are a couple of questions here about Google. And Becky has been in extensive conversations with Google. And if you get our emails, you've seen we have some really exciting exclusive partnerships with Google. And it means that Becky has talked to Team Google extensively, including about some G Suite offerings and things like that. So if you have questions about that, please let us know. But Becky, there are some questions here. Thomas in particular asked that he has reached out to Google to try to get them to sign their 2D agreement. So Thomas, I will also say, teamwork makes the dream work. If you have a 2D agreement, there are other folks on here who are asking about 2D agreements, and if you're willing to share it, we're happy to help facilitate that. But essentially, Google is telling him either sort of sign up for and pay for G Suite and we'll talk, or don't pay for G Suite and you get what you get and don't get upset. So Becky, would love to know in any of your conversations with Google if these sorts of things are on their radar, what you would advise, or if any of our partnerships with them might have future implications for their answers for things like this.
Sure. So our partnership with them, so we're working with Google for Education and Education Collaborators, one of their implementation partners, on a partnership that would allow us to get a bunch of licenses on computers and a bunch of training. But that does not sound like the situation that was asked about. The situation that sounds like it was asked about is a situation that we're all familiar with, where someone sends you a Google Doc and you are not a G Suite user, but you want to use it and collaborate on Google. So I can ask them about that. I'm guessing that they do not want to sign an agreement because someone is not officially paying for their platform. But let me ask my contacts at Google for Education. And if anyone else has any similar questions about working with Google or Google for Education, please send them to my email. It's in the chat there, because I'm happy to sort of get us all together and ask our big questions to avoid everyone having to send the same questions a bunch of times.
Awesome, Becky. Thank you so much. Kirsten?
I would add to that there are some BOCES that have already adopted 2D agreements with Google and Zoom and Microsoft Teams. And while obviously charters are not part of BOCES, I do think that those kind of riders or those 2D agreements are pretty publicly available. And so it may be a good idea to approach those companies through that lens of like, listen, you already have this going on in New York State. All we need to do is like be added to the list.
Right. Yeah. Well, so Kirsten, that's a great segue. Francis asked a question. We're a New York City charter school and have been trying to find out how to join the 2D agreement vendors like Google that have made with BOCES or the New York City DOE, but haven't been able to get those answers. They were originally told they had to join the BOCES agreement, and then BOCES told them they had to join a New York City agreement. So any insight into that? And I would say, even if you don't have specific insight into, how to sort of solve that game of hot potato, how could Francis and their school sort of document these efforts, right? So that as of October 2nd, they could essentially say, it's not for lack of trying or lack of awareness, and we participate in these same things. We just don't yet have the sort of thing in writing.
Yeah, so I think it's really interesting that BOCES have stepped up, and RICs also, which are these regional information centers, have stepped up to take the lead on some of this work. And I think that the question that Lauren is asking is a really good question for David Frank. Since BOCES are directly affiliated with the state ed department, it seems like there should be a conversation about whether there are extensions for charter schools in terms of those agreements. The way those agreements work, however, is that you are purchasing that service through BOCES, right? So you are, it's called a COSER, right? So you are like going in on the, you're contributing to the pot of money that it costs to use that Google service. There are not provisions in the law that allow charters to participate in COSERs. But that said, as I said, like the fact that these agreements already exist in New York State for a whole bunch of schools and districts should open up the door for David, hopefully, to at least have that conversation internally at State Ed.
That's a great recommendation, and I'll say to everyone listening that tune in on Tuesday, preview of coming attractions, when I will ask David that question. So then, as a related question, should schools that interact with systems that are run by their host district or the state, should they assume that they are in compliance? So if they are actively pushing like the most detailed student PII up to the New York City DOE, the Rochester School District, to SED, should they just assume that those systems are in compliance and are safe? Or do they need some documentation because they are actively, consistently sharing student PII with those entities?
That's a great question. So other educational agencies, that sharing of information between educational agencies is not covered by 2D. So you can, without worry, be sending information to New York City DOE or your district for special ed, excess cost data information. You can be sending it to BOCES, maybe for special education services, whatever that looks like. The only time that you have to think about whether you have to have a 2D agreement in place is if you contract for BOCES directly for services. So at some point, BOCES stops being like an education entity and becomes like a service provider.
Mm-hmm.
And so there may be instances where 2D gets implicated. But that would be a great question in very specific circumstances to work through with your council.
That's great. So another good question, especially in the current context, because we know a lot of schools, and including some platforms that we've made available through bulk discounts for parents to do the COVID self-assessments, these health screenings that are required on a daily basis. How do those engage with 2D? Would you say that they also need a 2D agreement?
That's a really good question. I suspect that I have to think about that. I think that's a really good question. I suspect state ed would say yes, that those are 2D covered entities. I'm not sure that the law necessarily reads that way. However, if you have, so are you talking about like you've purchased software app for parents to like click the daily health form?
Exactly.
Yeah, I think those are 2D eligible. That 2D applies to those organizations.
I agree. I think, well, so I think a follow-up question that I would ask is my expectation and my knowledge based on, again, Becky, shout out, Becky's research into a couple of platforms for which we achieved some bulk purchasing agreements, because they have HIPAA information. They already have significant safeguards, if you will. Would you still recommend a 2D specific agreement in a contract with a school?
Yeah, because it's all about the breach, right? And the unauthorized disclosure. So even if they are, super HIPAA compliant, FERPA compliant, IDEA compliant, and some other organization has already checked all that out, if and when there is that, they get hacked, and they do need to call you and say your student's data has been compromised. If you don't have a 2D, if you don't have the language of 2D in your contract with them, they're under no obligation to let you know, which means you can't let your families know.
And that's not HIPAA. HIPAA, right? Like that's where you're saying that's the difference. Interesting.
Yeah. So you have to be able to let your families know, and that's where you end up out of compliance with 2D.
That's super helpful. And Becky dropped in the chat a link to the bulk discounts that I was referencing. So Magnus is the health tracking app, which has already said that they are 2D compliant and are ready to make agreements. And then an interesting tool that I wasn't aware of until Becky's great work is ClassLink, which is a tool to actually, if you feel challenged to sit down and make this list that Kirsten and I were talking about what are all the platforms that people are using and engaging with, ClassLink is something that can be helpful with that. And I will say, I typed an answer, but I think it will be worth answering live, because I think everything that I just said, I know folks are super worried about cost right now. And I know, this deadline is coming up relatively quickly, but there is not going to be an additional extension as far as we can tell. October 1st already represents an extension. from when this is going into effect, and it's for more than just charters. But if there are things that we can do to be helpful to schools, please reach out, and we're happy to do everything we can to be helpful. So Kirsten, a couple of additional sort of weedy implementation questions. So for the board policy, is this something that a board should formally adopt at a meeting? And then how or if should it be shared with staff?
Yep, so yes, the answer is yes. It's a board policy, so it needs to go through your regular process for board policies. And then there is the annual notification requirement, and the requirement that the policy be posted on your website. And so you can share this with staff in whatever way you would normally share other information about board policies with your staff. Again, I think it is worthwhile to take some time and build just even an initial conversation about what 2D is into like a regularly scheduled, Friday PD session, carving out 10 minutes and saying, there is this new law, we're working on implementing it for folks who are not ready. And really for me, it's about making sure your teachers know before they agree to those terms and conditions that they must agree to unilaterally, right, before they're allowed access to anything, that those are no longer, they can't do that anymore. And just start to kind of like get people thinking about how many things this applies to, but maybe without scaring them to death right now.
Well, that goes back to, and I'm happy to share, I'm sure I can dust it off somewhere, a very short, very funny 30-minute PD that I wrote at some point to scare people away from doing crazy things on social media. This idea of like whatever you write, it lives forever. So Mark asks about a charter school's yearly audit. So when an auditor requests information, do they need a 2D writer? Because sometimes they do audit things like FERPL or student billing, things like that. Would that be a third-party vendor where you would add a 2D writer to their contract?
Yep, absolutely. Yep.
Great. And so then Heidi asked a question, is the state providing training? Or is this something that every school is doing on their own or identifying a vendor? And if the answer is identifying a vendor, do you know of vendors? And I'll sort of be honest and put our hands up and say if the answer is no, and this is something that schools feel like they need, that we as the association could lean in here.
I think that would be good. The law is really clear that it could be online training. So you could have, I know, our firm a couple of years ago put together online sexual harassment training. We've been talking about getting online 2D training. So kind of people in their own time can kind of go on and certify that they've completed the annual training. So back to the first part of the question, is the state providing training? I've heard nothing about that, so I don't believe so. But again, another question that maybe just to confirm with David that that's not going to be an option before the association takes that on or whatever next steps would be.
That's super helpful. We'll look into that, and I will take this opportunity to say to folks that we are planning a statewide conference coming up in late October, and that if we don't have clear, I know it's after October 1st, but we're gonna maybe if we have it planned by October 1st and folks are signed up for it, that could be something that we make available then. That could be timely. So Karen asked a great question that's not one that honestly I had thought about in terms of liability insurance that vendors should carry. So often when you are contracting with a third-party vendor, they share a certificate of liability insurance. Is there an amount that people should be looking for if they are a vendor that receives PII?
I am not an insurance attorney, so I'm going to say that as my kind of disclaimer up front. One of the things that I noticed though in 2D is that it does not impose kind of policing obligations on the school. So that's why I tried to say when I was talking about the third-party contractor obligations, these are obligations that are like independent of the school. And aside from really making sure that that plan, that data security and privacy plan that the vendor puts together that gets incorporated into your contract with them, aside from making sure that it meets the requirements of the regulations, schools are not charged with policing their contractors. And so the other thing I'll say is there's no private right of action in 2D on schools. And so, you know, if meaning, you know, Google had a data breach and Johnny's mom now wants to sue the school, or you know, there's no right of private cause of action in 2D that would allow her to do that. So I'm not as concerned. I'd be more concerned, frankly, if I owned a, you know, a software company, where there's, you know, there's kind of the investigation, civil penalties, being prohibited from doing business in New York for 5 years. You know, so there are big levers that the state can pull, but they're not levers that the school can pull. So, you know, I would probably say that the insurance is not your biggest kind of priority right now.
So let me just test my understanding on that. Unlike some of these third-party contracts where injury to a student, for example, right? You use an outside space, you hire a bus company, something like that. You care about the liability insurance of that third party because it can help to cover you, the school, in the case of an incident. What you're saying is that the liability structure of 2D law, that sort of water never flows back downhill to the school, where the school needs to make sure there's an extra pot of money to protect themselves in the case of a data breach. Am I getting that correct?
I would never say never, because that's how lawyers, you know, make money, right? So I would not say that. I mean, I think people could certainly add to their to-do list to check with their insurance carriers, but you've been sharing data for countless years anyways with these third-party vendors. What we're really talking about now is that, like, they have an obligation to protect it better, and so do you. And so if you are like meeting the requirements of 2D, you are not being negligent or reckless, right? And that's why I mentioned you're not responsible for policing your vendors. So if they are reckless, you know, that to me is kind of on them based on the framework of 2D.
Well, and this is why I love you, Kirsten. You're always honest. And so if you ever want the real deal from a lawyer, call Kirsten. I will also say, and I wasn't trying to tee that up, we do have an insurance webinar next Thursday because there are some specific considerations, especially in the COVID context, around things like liability that we've been getting a lot of questions about. And not only are we not lawyers, we're not insurance people. And so if you have insurance related questions about this or other liability issues, please join us next Thursday. So I realize that we're at 5 o'clock, and I so apologize because 10 minutes ago, Kate asked potentially the penultimate question, and now I'm leaving it to the very last minute. But Kate is saying that in the New York City Charter Center shared at some point that they have taken the position that 2D does not apply to charter schools. Has there been updated guidance addressing whether 2D applies to charters? So I'm going to take a stab, and then Kirsten, I'm going to turn to you, and I'm going to say, I don't know what they said or when they said it, but this is not the time to take a philosophical position about what laws do and do not apply to charter schools. And while there may be a higher order legal or philosophical argument about the origins of charter autonomy, I would strongly discourage anyone from using this issue as an example or a time to think that that is the case.
Yeah, I wonder if maybe there was just a misunderstanding or something, because the regulations, the definition of schools reads, school means any public elementary or secondary school, including a charter school. So charters are explicitly included in the definition, and maybe our friends at New York City just either misspoke or, you know, missed something, but definitely this applies to charter schools.
Thank you for that. So with that, at 2 minutes over, and apologies to folks, I'll turn it back to you, Yomika.
All right, great. Thank you. This was absolutely chock full of information, pertinent information, and I know that schools can't wait till we post it on our website. Share this with other folks. And thank you very much, Kirsten, for being with us today. This was, again, a great, very informative conversation. I'm sure we'll get more questions and have follow-up, so thank you also for providing your email for follow-up questions. We have information that we have dropped in the chat to contact Google or contact Becky for Google or other information. We will see you again Tuesday for our weekly webinar. Again, Kirsten, thank you very much. We hope you come back again. Stay tuned. Next time we'll talk insurance, and again, see us on Tuesday. We will follow up with David on the questions about SED in this issue. Have a good night.
Thanks, everyone. Good night.